Who is responsible for Taiwan's defense?
Part 101.
A case study of executive branch inaction.
Sovereignty issues in Baja California.
The Mexican-American Peace Treaty stands out as a notable example of a dispositive treaty wherein numerous determinations concerning territorial boundaries are to be established subsequent to the treaty's coming into force, which occurred on May 30, 1848. These determinations are, however, considered integral components of the treaty, as articulated in Article 5.
Within this context, it is within reasonable consideration to envision the following hypothetical scenario. Of importance in dealing with the Taiwan status issue will be to contemplate the significance of the content of the Q&A offered at the end.
Scenario involving Baja California.
Let us imagine that during the negotiations leading to the treaty, both the Mexican and U.S. negotiators acknowledged that the Rio Grande River, which delineated the eastern segment of the newly proposed Mexican-American boundary line, for an approximate span of 1,255 miles, 2,020 kilometers, 1, exhibited a propensity to alter its course over time, commonly referred to by local inhabitants as jumping its banks. And furthermore, 2, it became apparent that if this deviation exceeded 200 meters towards the north over a designated period, it would result in a significant territorial loss for the United States.
In light of this, considering a century-long timeframe, the negotiators established that should qualified geologists validate such a northward change in the course of the Rio Grande River, Mexico would make a one-time cession of a distinct portion of territory to the United States as compensation.
Precisely outlined within the so-called supplement to Article 5, separately designated as Article 5-1, the specific tract of territory to be ceded encompassed a portion of the Baja California Peninsula, extending from the initially agreed-upon boundary, north of Tijuana, down to the 29.5-degree north parallel, which traverses the southern tip of Isla Ángel de la Garda in the Gulf of California.
Significantly, the transfer of title for this territory in Baja California had already been concurred upon by the Mexican and U.S. representatives at the time of treaty ratification in 1848. This concurrence was executed with duly authorized signatures and seals, and mandated no further negotiations for its implementation, according to the conditions stipulated, beyond May 30, 1948.
However, although totally optional, the enforcement of Article 5-1 could be substantiated through the issuance of a concise document, not exceeding 5 pages in length, either by A, the majority leader of the U.S. Senate, or B, a committee composed of 6 senators chosen from the upper echelons of the Senate membership.
Consequently, during the early 1950s, a collaborative team of U.S. and Mexican geologists undertook meticulous on-site investigations, ultimately confirming that the Rio Grande River had indeed undergone a deviation of more than 200 meters over the course of the previous century.
Thus, it was ascertained that the cession of the designated Baja California segment to the United States should be deemed effective as of May 30, 1948.
Response from executive branch officials.
Nonetheless, when U.S. historians, geologists, and legal researchers brought these findings to the attention of U.S. executive branch agencies, the officials involved exhibited significant reluctance to engage with this matter. Their reasoning rested on the existence of numerous ongoing negotiations with the Mexican government concerning other significant affairs. In this context, the Baja California territory issue, entailing the re-examination of an antiquated treaty, was regarded as unsuitable for immediate exploration.
The following Q&A are offered for reference.
Negotiations with U.S. officials.
Question: do U.S. government officials possess the discretionary authority to selectively enforce or disregard disputes pertaining to boundaries and corresponding territorial matters, particularly those entailing the extension of U.S. administrative authority, whether civil or military, over specific geographical regions?
Answer: the Mexican-American Peace Treaty achieved ratification by the Senate. As per the U.S. Constitution, any instance where government officials dismiss the stipulations of a Senate-ratified treaty constitutes a violation of several constitutional clauses, including the Supremacy Clause, Article 6, Clause 2, the Faithful Execution Clause, Article 2, Section 3, Clause 5, and the Treaty Clause, Article 2, Section 2, Clause 2, among others.
Nevertheless, it is plausible that the officials in question would find characterizing their inaction as substantial breaches of their constitutional obligations less than agreeable.
In a related context, it merits acknowledgement that within the framework of the United States legal structure, the determination of sovereignty over a specific geographic area, is classified as a political question, thereby rendering the judicial system an unsuitable arena for private individuals to contest this matter.
Having said that, if the state of California were to pursue legal action on this subject, the prospects for success would be notably more promising.
Upon thorough consideration of all feasible courses of action, the most judicious approach appears to involve identifying U.S. senators or Congress members who evince some level of interest in this issue. Through their involvement, it is much more likely that executive branch agencies could be encouraged to adopt a more proactive stance in pursuing a resolution.